Welcome everyone. I think we should start even though a few people are still joining the event, but we should keep within the time that we have. So we will welcome everyone. Good morning and thank you very much for your time to join this event today. This session is focused on looking at the financial accountability of perpetrators of torture and other grave human rights abuses. My name is Alejandra Vicente and I'm the head of law at REDRESS. I've been practicing as a human rights lawyer for more than 10 years. Before joining REDRESS, I worked at the Center for Justice and International Law, conducting strategic litigation of human rights abuses in Latin America. And prior to that, I worked at the International Criminal Tribunal for the former Yugoslavia for 5 years. Today, I'm here with my colleague, Jonny McQuitty. Maybe, Jonny, you can introduce yourself.
Sure, thanks, Sandra. So, hi all, thanks very much for joining us. Just to introduce myself briefly. So, I'm a legal consultant working with REDRESS. Just by way of brief background about myself, I previously worked in prior practice, and my practice specialized in mass claimant actions, particularly in the environmental litigation context. And also in public international law. And I've been working with REDRESS on a project looking at how we can promote financial accountability for perpetrators, which is the subject of today's presentation, and particularly working with the support of KPRSL on generating some materials to sort of build and develop this work. Thanks, Sandra.
Thanks very much, Jonny. And just to say that we also have with us Liana Bernard, who's actually joining from Australia. And she's going to be taking notes. Here is Liana on the screen. And she's the lawyer at REDRESS, specialized and working on asset tracing and sanctions. So thanks for joining despite of the time difference. Before I give a brief overview of today's event, I would like to introduce REDRESS as well, which is the organization we work for. REDRESS was established more than 25 years ago by a survivor of torture. And so with a core mandate of assisting survivors of torture to obtain justice and reparations. And because of that, reparations are very important for us, is part of our core mandate. And that's why we constantly look at the difficulties that victims face in obtaining reparations for the harm that they have suffered. And that's the main reason why we have an interest in exploring financial accountability of perpetrating torture and other international crimes as a way of recovering some of those resources and using them for the purpose of reparations. Before I go further, I would like to ask participants, if that's possible, to answer a couple of questions. We have a little poll that you may see on the screen any minute. And if you could please help us by answering the questions, that will be really helpful to know how much knowledge we have in the room, in the virtual room, and then we will share the results at the end of the event, of the meeting, if that's okay. Now turning into the program, the event today looks at the framework, a document that we have published, which explores different models to achieve financial accountability in cases of grave human rights violations. We are going to start by defining the problem that we are looking at. We will then explore the response that we propose in our report, and we'll address the important issue of collaborative and cross-sectional learning and partnerships in this field. We will at that point open a discussion and feedback session for participants to interact with us and share their views. And I would ask that in that session, you please raise your hand. You have that option on your screens so that we know you want to intervene. Or if you prefer, you can also send us your question by the chat function that you have at the bottom of your screen. Or even if you prefer, you can just send us a message privately if you don't want your identity to be disclosed. After that first session, we will explore some of the specific models that we have developed or explore to address the issue of financial accountability. And we will open for second discussion session before we close the event. So without further ado, I give the floor now to Jonny so that he can start the presentation. Jonny, go ahead.
Thanks, Sandra. And so we'll be starting by our conceptualizing of the problem, which I think is helpful for sort of establishing the framework of what we're looking at. So today's session and this program of work is really concerned with the issue of financial accountability. By that we mean the fact that perpetrators often profit from abuses, and in turn they're not deprived or denied the benefit of those assets. So there are a couple of ways that perpetrators profit from abuses. There's of course direct flows. So if you imagine a perpetrator who takes part in pillage or who expropriates a victim's assets by threat of force or by use of force or so on. So that's kind of, one way of doing it. But we also see a way that perpetrators profit from abuses in an indirect sense. So, that might be, for example, through basically destabilizing a regime, introducing security services or deploying security services to facilitate corruption or other looting of state resources. And indeed, we think that's one of probably the more significant issue, and one of the particular conclusion that's come out of this project is the very strong link between corruption and human rights abuses, the way that human rights abuses can facilitate and support a system of grand corruption. In terms of conceptualizing the issue, there is of course a general accountability gap for perpetrators, notwithstanding the very significant efforts of groups of governments to provide accountability for perpetrators. There is nonetheless an accountability gap, but we think there is a specific deficit for financial accountability. By this we mean there's a failure to deprive perpetrators of assets. That might be, for example, by failing to obtain confiscation measures against a perpetrator, or failing to achieve compensation awards during criminal proceedings for the benefit of victims. But also, even where that does take place, is a failure to ensure that there is compliance with those compensation awards. The net effect of that in any event is the same. It is that perpetrators remain or continue to have ownership, use and enjoyment of assets. Meanwhile, victims who have suffered harm as a result of abuses are left without reparations. They're left to face the practical consequences of the harm that they have suffered. For example, their medical bills, psychosocial support, lost earnings if a family member is killed or disappeared. And so in that sense, there's a real failure to achieve justice for them. Thinking through the consequences of this accountability deficit, there's a particular issue around perpetrators profiting from abuses. And I think there's two particular points that we can draw out here. One is the general contribution to impunity. If a perpetrator is able to obtain assets as a result of human rights abuses and no action is taken, that is very much a contributing factor to a sense of impunity. And taking it a step further, one might even suggest that it is, or it can provide an economic incentive for violations and serious human rights abuses. If it will make your pilfering of a state more effective and there's going to be no accountability, then there's no real barrier to undertaking those abuses. For victims, of course, there are very significant consequences. First off is the failure to achieve justice. As Sandra said in the introduction, Redress works extensively with victims of torture. And one of the key issues is about ensuring that they achieve justice, of which reparations is a very key or a critical component. It's a part of achieving justice. It's one of the fundamental principles of righting wrongs. For any international lawyers, it's the sort of the foundational principle of cause factory. You're trying to put the victim back in the place they would have been but for the harm that they've suffered. There's of course the practical question, which we've touched on already. And victims, rather than enjoying their right to reparations, are forced to rely upon donors or the discretionary support of states, which is not the same as their entitlement as a matter of international law to reparations. There's obvious knock-on consequences for trust in rule of law, trust in states, public institutions, and justice systems, which, for example, in a post-conflict system is not helpful when trying to rebuild those institutions. And I'd also just take a moment to tease out the consequences for developed nations. This is not a localized issue. The consequences of financial impunity and the absence of financial accountability are felt around the world. For example, as a Brit, we're very aware in London about the impact of dirty money on the London real estate market. Just as a quick stat, 60 to 80% of, approximately 80% of 80% of high-end luxury properties were purchased by overseas buyers, of which 60% used complex identity shielding ownership structures, which suggests, well, you know, there are some legitimate reasons for privacy, but I think we can infer from that, you know, the scale of the problem. But it's not a recent one. You know, in the context of the US, for example, there's the example of Riggs Bank, which fell or collapsed in the 90s as a result of money laundering that it was basically part of, laundering the proceeds of organized crime in Russia. So basically what I think we're trying to say here is this is a problem that affects us in developed nations as well. It's not just a localized problem based on where the perpetrator and victims live. I thought it might be helpful just to conceptualize this problem by looking at a couple of live examples. And so we'll look at Yahya Jammeh and Habré, and they cover two distinct sort of points here. So Jammeh, of course, former leader of Gambia and involved in extensive human rights abuses. We won't go through those in details. I mean, he's notorious. I mean, the Jongleurs unit of the Presidential Guard, I think, is notorious for their brutality. But I think the thing that's interesting about Jammeh in the context of this project is the very clear link between corruption and human rights abuses. So as a kind of a conclusion, or to illustrate the scale of corruption involving Yahya Jammeh, he's thought to have orchestrated the embezzlement of about $1 billion. So just a few numbers: 360 million from a state-run telecoms company, 325 million in illicit timber revenue, appropriating more than $100 million in foreign aid and soft loans from Taiwan. And that's just the beginning of a very long laundry list. And again, touching on that point about the effects of sort of the overall global financial system, this pilfering was done with the support of finances of Hezbollah, the terrorist group Hezbollah. And it sort of shows the connection between, or the sort of the web that these activities take place in. So Jammeh, I think, very successfully leveraged his human rights abuses to facilitate that corruption. That's a conclusion that not only we've reached. I've included a quote from the OCCRP just at the bottom here. They've done a fantastic report on this, sort of detailing a number of examples of the brutality. But I mean, the point here is, it's his, quote, ruthless control of governments and institutions that leveraged or provided the means for Jammeh to strip Gambia of its resources. It's that use of human rights abuses. So I think that really makes that point about the link between corruption. I should also say that at the moment, steps have been taken to freeze Jammeh's assets, the ones that are located in Gambia, but there is a big gap at the moment in terms of pursuing his international asset footprint. Habré, former dictator of Chad, is an example of, I think, the point about non-compliance with awards and about how we kind of need to make sure that the efforts go through to both not just securing an award of compensation, but actually ensuring that it's put into practice. So, of course, involved in extensive human rights violations that will be well known. Involved in corrupt behavior. For example, approximately $1 billion of Libyan military equipment was captured by Chad following the Libyan-Chad war in the 80s, which was subsequently sold on around the world and generated significant financial flows. So Habré has been held accountable. He was subject to criminal prosecution by the Extraordinary African Chambers, and bar a small exception for COVID, has been in jail since, which is great, and we should celebrate that fact. We should also celebrate the fact that the EAC issued a compensation order of about $150 million, but there has been a failure of him to comply with that orders, which means that while victims have the benefit of that judgment and the moral side of it, they're still left with the practical consequences that it hasn't been complied with. And I should say there's another judgment for context to illustrate this problem is pervasive. The Chadian state, together with former members of the state security services, are jointly liable for another judgment worth approximately 125 million. And that also hasn't been complied with. So moving on to our response. So our response is very much about addressing the financial accountability deficit. And what we've been doing is trying to identify mechanisms that can be used to achieve two things. One, first off, to deprive perpetrators of assets, or at least their use and enjoyment. So that's the first limb, the perpetrator and their relationship to assets. Secondly, is that where possible, we would use those assets to fund reparations for victims. The reason that we've distinguished between those two limbs is because they are two separate points. And some of the mechanisms that we've explored will achieve only one, particularly the first one, without necessarily achieving the second. That doesn't mean they don't have value, but I think we want to, be clear that there is a difference in the models and mechanisms that we've identified. Throughout this process, and I think in keeping with Redress's core values, we want to stress the importance of victim-centric approaches. And very much in terms of the work that we've done, it's not so much that we're looking to reinvent or even create the wheel. I think we recognize there's an incredible foundation of work that's been done. The Habré case is just one example. We'll touch on others. But we think that there is room to build and to develop. And we think particularly that there's room to build using expertise from other sectors like the anti-corruption sector, law enforcement sector, and to try to adapt and use models that they've developed in this context. And as part of that, basically we've been looking at how we can put these mechanisms into practice through pilot cases, which we won't talk about in detail here, but we'll go through some of the evaluative process in the second half. And I think just another key takeaway, which will come up a number of times, is the value of cross-sectoral learning, as Sandra noted at the beginning. It is, I think, a very important thing and something we're very keen to promote and encourage throughout this. So as Sandra mentioned, with the support of KPSRL, whose very generous support we gratefully and gladly recognise, we prepared a framework which is designed basically to set out these models and these mechanisms to help use it or put those models in context so that you can develop case strategies around particular cases. In terms of audiences, we've written it to be accessible. It's a fairly technical document in places, but we still try to keep it accessible so that we can sort of draw in and encourage that cross-sectoral learning. We'll go through the mechanisms on the next slide, but just to say it describes a number of mechanisms, but also goes into some of the tools and techniques like asset tracing, specialist funding for these sorts of claims, just to provide a starting point for thinking about how that shapes case strategies. And there's an accompanying policy paper with recommendations. I should say both of these papers are available on the platform. I think if you search financial accountability, they should come up. But if you can't find them, then please feel free to email us and we'd be glad to share copies with you. So these are the models for financial accountability that we have within the framework. And as you can see, they cover a range. They go all the way from private civil claims, which are claims by victims themselves against perpetrators directly, basically down through to more informal, at the far end, more informal, soft advocacy to financial institutions to look at ways that we can basically use advocacy to achieve the effect of restricting access to financial institutions. I think the main point here is that, and as we'll see later on, is that the models vary. Different actors are involved in different models. They have different resource requirements associated with them. They involve different evidentiary standards, different levels of victim participation. And ultimately, they lead to very different outcomes. And so I think it emphasizes that there is no one silver bullet here. That's not the point of this framework. There is no one model that works for all cases, but rather what we've done is present a selection of models that might work in different contexts for different cases. I should say that the suitability of particular models may vary over time, depending on whether, for example, a perpetrator moves or where the assets are located. So it's a dynamic process that goes on throughout the life of a case. And now just to talk about cross-sectoral learning and partnerships. As we said, we think that there's very significant value in terms of cross-sectoral learning and partnerships for developing this area of work, for moving it forward. And we see that particularly in terms of the adaptation of existing tools and techniques. So the anti-corruption sector, for example, had developed legal mechanisms, investigatory tools that we think could be very helpful for building these claims. But there's also the specialist technical knowledge and expertise that's important for building and developing these claims, for the factual investigation side, for asset tracing. So just to draw on a couple of specific points, and apologies if you can hear a doorbell in the background. I think there's someone trying to make a delivery, but we'll just ignore it for the moment. So the anti-corruption sector, We've discussed the link between corruption and human rights abuses, and we've seen a worked example of that. And I touched on previously the fact that there are established mechanisms to seize the proceeds of corruption, which we think could be particularly helpful. There's a couple of other points that I think we would make, that the anti-corruption sector is sort of designed really about that first limb, about pulling the assets away from people who've participated in corruption. But within that sector, for example, there's a growing recognition of the importance of victims in that process. So in the UK, for example, there are principles about compensation or the distribution of the proceeds of corruption to include recognition of victims. And so we see that area is very synergistic, for example, with trying to prioritize the position of human rights abuse victims in the context of proceedings. We also see, for example, mass claimant claims, and which are, just to sort of characterize these are claims that might be brought following major environmental or industrial incidents where a large number of people are affected and a claim is brought against the company or other person that's responsible. These are very interesting claims because specific procedures have developed basically to facilitate claims by large numbers of people against specific wrongdoers. So we think that we can make use of those to provide a prototype for human rights claims. And similarly in the commercial context, again, it's an example of drawing on their specialist sort of knowledge and expertise. One of the key issues we face in human rights claims against sophisticated, if you could call them sophisticated, or the higher net worth perpetrators, that often they will use complex structures to hide their assets. This is something that comes up a lot in the commercial context, particularly in commercial fraud type cases, you know, where you're looking to basically find assets that have been fraudulently obtained or stolen, or, you know, through white collar crime type principles, and basically to bring those back. So there's a lot of very specialist expertise in that sector that's very relevant for the work that we're doing. But also there's a significant degree of resource there that we think we could mobilize. So for example, whether we can use the same resources on a pro bono or a very reduced cost basis, and that's something we've seen success with already. So with that whistle stop tour, perhaps I can hand back over to Sandra to talk about, or to go through some feedback on that.
Thank you very much, Jonny. And as you can see, we've discussed up until now how we see the problem, the lack of financial accountability. What's the response that we propose in our document, which is basically to look at a number of legal models where that we could use as practitioners to get into those assets. And we will discuss them in detail in the second part of the session. And finally, we've highlighted the need for collaboration and also for cross-sector assistance and learning. And at this point, we would like to very much seek your feedback on what you have heard so far. And to do that, I'm going to ask a few questions to trigger the discussion, but obviously you can feel free to participate with any comments you have outside of these questions. The questions are, do you share with us that financial accountability in relation to international crimes is often overlooked, and that this has an impact on victims and affected communities and their right to be repaired for the harm they have suffered? Or do you believe that this is an area that is sufficiently covered so far by international institutions and others? We would also like to know if among the participants there are others that are looking at these issues, and if you have any particular experiences that you would like to share with us, good or bad. We would also love to hear from you. What are the challenges that you see, that you've read, that you have experience with through your work in this field? And whether you see and you agree with us that there is a need for more collaboration across sectors, including enforcement agencies such as Eurojust, civil society, international courts, investigators, journalists, etc. So if you could, please don't be shy. We really would like to see this as a conversation. And if you want to participate, please raise your hand and introduce yourself briefly if you want to, but you can also include questions in the chat. Let's see if there is anyone that wants to participate. I see Claire has raised her hand. Claire, please feel free to intervene.
Hi, yeah. Thank you so much for the presentation. It was super interesting, and especially for us. I'm the Deputy Director of Victim Advocates International, and we provide direct legal representation to victims, and financial, like tracking the money, is something that we've been thinking about a lot, particularly in relation to our Rohingya clients, and it does seem to be really unexplored. And
Hi, Claire. I don't know if it's only me, but we lost you there for a second.
Come up with some... Oh, did you? Can you hear me now?
Yes, we can.
Sorry, I'm in Lebanon and the internet is really bad at the moment. Yeah, so I think our challenge has been that because we're a small team of people that understand law but not money, we've kind of we have taught ourselves a little bit how to do it, but it's just so time consuming, I think, if you don't have the expertise. And then I think when we've reached out to people that are financial investigators as a profession, it's so expensive. And I think the challenge for us has really just been like trying to find the resources to be able to invest in that process, which I think if we were able to do that, it would provide a lot of extra options in terms of justice for the people that we represent. But we haven't really been able to find a way to make it work yet.
Thank you very much, Claire. I don't know, Jonny, if you want to give a reaction to that.
Sure. Claire, thanks so much for that. It's really interesting and of course, always heartening to hear about people working on this area of work. I think the problem you describe is one that we recognize. I think if just to offer some kind of perspective, I think based from our experience, one thing we found has been very helpful in terms of, I think, at a preliminary stage, so not the full case building, but basically I think establishing the viability of claims is looking for partnerships on a pro bono basis with asset tracers. And I appreciate that's not always possible, but there are some firms, and particularly the bigger ones, I think, that can offer that support to do the preliminary screening. That being said, there is still a need to meet the costs often of that work, and that's what we found. So there's, I think, no way around that. But I think it also brings in another question, which is about the funding of these claims, and it's something we've explored in the framework. And I think it's a tricky question. It's a one we haven't worked out yet, but we are very interested in the idea of whether it's possible to draw on commercial approaches around funding of litigation, basically looking at recovering the costs of bringing a claim against a perpetrator as part of bringing a claim against a perpetrator. It's something that needs to be done very sensitively. The traditional commercial funding approach doesn't really work, but the principles that underlie it, we think, are very interesting, and if they can be made to work, could provide a way of making this work self-funding. But I think that's very much at an early stage and needs a lot of further work and thinking through before we can kind of, I think, establish a position on that. But that's something we're looking at. So I'd encourage, if it's helpful, those are two things I would think worth looking at.
Thanks. And I would also highlight the fact that, as Claire said, in her organization, they know about the law, but not about the money. Something we are trying to do with this document is to trigger that type of exchange, because we see that, for instance, enforcement agencies may have certain expertise that is quite relevant in the anti-corruption area, or even at looking at terrorism cases. But sometimes they miss the human rights angle where we have the expertise. And we see, as Jonny was pointing in some of the examples, there is a real connection in some of the cases, but it's often not explored. So I think that's quite relevant. I wonder if there are other interventions, questions, comments, feedback on what you've heard so far, experiences that you have, or anyone looking at these issues in the audience? No, everyone is shy this morning.
Well, I can say something. I was trying to raise my hand, but it's...
Okay, sorry that we missed that. Please introduce yourself and go ahead.
I'm Harry Hamel. I work in the Netherlands Helsinki Committee. One of the things we've been doing now for a couple of years is work with a small group of investigative journalists on what we call Russia-European Union transborder corruption. This is, a big chunk of this is channeling of corruptly obtained money from Russia to, Western banks and investments in Western places. The case of, London, London housing market was already mentioned, but there are many more examples. One thing that we try to find out is how, European Union prosecution mechanisms work or don't work in relation to these cases. And you see that but I think that there is a lot of scope to also look at, mechanisms to, question the, or explore the possibility to strip people of their assets. This is something that we, in the UK, again, you have the unexplained wealth order, which was used, once or twice against former Soviet countries, oligarchs. First it looked successful, then it looked not so successful, but this is a legal battle that I think needs to be taken on, not just in the UK, but also in other places. Then there is the anti-corruption field, more specifically, where you've had cases in the past in Kazakhstan and now a legal battle over Uzbekistan, in the corruptly obtained assets that were impounded in Switzerland, United States, Netherlands, that, in the case of Kazakhstan, where, a scheme was introduced to actually try to use the money in socially responsible ways through a special foundation in Kazakhstan, which was constructed, or it was argued that this would benefit the victims of the corruption. In the case of Uzbekistan, this is a mobile phone company, so basically the victims of this corruption, which involved the daughter of the then president. This, the victims were all the mobile phone owners who, had to pay higher fees because of the corruption. The battle now is over whether these assets that, I think still are frozen in a couple of countries, whether they can be returned to Uzbekistan and then used in some way, and what this way exactly is. There is a group of Uzbekistani human rights organizations and anti-corruption activists who are working on this. More generally, I very strongly believe in, the importance of linking these different fields, and I'm quite enthusiastic about what you said about the prospects of this, and I think it's a very underdeveloped area. I also agree with, the idea that you could, or that we should explore, a business model for human rights NGOs, or more generally human rights and anti-corruption NGOs, in trying to become more independent from the eternal donors, be they governmental or non-governmental. I think this is a possibility to start raising our own funds if we manage to develop successful models. And I think this is something that is very much in the beginning, and we should push this.
Thank you very much, Harry, for that intervention. Very relevant, and you've highlighted also an important challenge, which is how to make sure that assets frozen through corruption or anti-corruption efforts go back to the victims. I'm gonna give the floor back to Jonny to react to your comments, but also to continue with the presentation. And if there are others that wanted to intervene, please keep it for the second session of feedback and discussion.
Thanks, Sandra, and Harry, thank you for that. I think a number of very interesting points. Just to pick up on the funding one, I think, yes, there is a real question about how we can use funding models and deploy those effectively to sort of, I think, ensure the long-term sustainability of this area of work, because these are not short-term cases. These are long-term cases that take time And without the backing of a donor who's prepared to invest over multiple cycles, it makes it more challenging. And I think that's something we really need to sort of get to grips with. So I think just to, so this is really the second part of our presentation, and what we're going to do here is to look at some of the specific case models that we've identified in the framework. I should make an apology in advance to any lawyers. This will be a slightly generalized and soft view of things. You can pick me up on all the generalizations we make afterwards, but I thought to make it accessible, we do these things sort of at a relatively high level of abstraction. But I think the point here of what we want to show is that basically these models, they have different outcomes, they apply differently, and they won't be relevant for all sort of circumstances. And I think it ties in to the purpose of the framework, which is really, basically, can we provide a menu of options that people then select from to get the best outcome in a specific case. So the way that I think we do this is, or the way we're going to do this is to take sort of three paradigm categories of perpetrators. So we'll have a senior, like head of state or very senior government official, and then maybe looking at someone who's a mid to high level or moderately high level security services member, and a facilitator, so maybe an arms trafficker or a conflict minerals trafficker. The point being with these is that they all have different characteristics, and those characteristics have bearing on the applicability or otherwise of particular models. So if we take the example of a senior regime official, we can imagine someone with a quote command responsibility for abuses. So they're not directly participating, but they're ordering in general terms or potentially specific incidences, but setting up general systems of human rights abuses. They're implicated in extensive corruption. So Jammeh is kind of I think the archetypal example of that, but you can sort of see how it applies to others. A substantial asset footprint, and particularly assets in a developed jurisdiction. So we've used the London real estate market as one, and the fact that assets are held in complex structures. And we've also considered their location, which is very relevant for these models. So if we imagine, as in the case of Jammeh, as in the case of Habré immediately after he fled, that they're located in a sanctuary or an uncooperative jurisdiction. Basically, they're in a place where it will be hard to bring claims against them. If you were to contrast that to a high to mid-level member of a security service with a much more close connection to abuses, whether they're basically effectively managing that process or if they're directly participating, but also with a much more moderate asset footprint. And thinking about the profile of some of the people we've seen, perhaps they've stayed in the original jurisdiction, or perhaps they've left to go to the diaspora, so they might be located in a developed nation or a global north country. And then facilitator, so indirect involvement, so provision of weapons or provisions of economic resources to enable violations, so particularly in a conflict context. Substantial asset footprint, these people make a lot of money from what they do, but they're globally mobile, they may be moving around, and from time to time they may be located in jurisdictions that are favorable for legal action. And just before we get into this, just as a reminder, what we're trying to achieve here, we have two goals. First, we want to deprive perpetrators of assets, so if we can't take the assets entirely, let's try and restrict their use and enjoyment of those assets. And where possible, apply assets for the benefit of victims. And I have here a victim-centric approach. The victim-centric approach is really important. It obviously depends on the specific case, and so we won't get into it. But I think just as a reminder that when you're applying these models, you need to take into consideration basically what the victims themselves want, what they're trying to achieve, and not to sort of to do it blindly. And that's particularly important when models have very different outcomes and consequences. So private civil claims. A private civil claim, this is basically what I was talking about in the context of mass environmental claims or mass industrial accidents. The idea is that you're bringing a claim because of the harm against a perpetrator for the harm that they've caused to you. So if you were to use a traffic accident analogy, the victim is the person who's hit by another driver. They bring a claim against them for the damage they've suffered. It's fairly fundamental principles of civil law. Just to give you a couple of examples of how this has worked in practice. So Ferdinand Marcos, victims of Ferdinand Marcos, who was the former head of state or dictator of the Philippines, achieved a $2 billion award against Ferdinand Marcos on this basis for the damages that they suffered. They've struggled greatly with the enforcement of that judgment, although lots of attempts have been made, but that shows the potential for this. Colonel Carl Durelian is a very interesting example. He was part of the 1991 coup in Haiti. subsequently fled to Florida, where with unbelievable luck, he won the Florida state lottery. But off the back of that, the family of a victim who was killed by Colonel Durelian's forces brought a claim against him and were able to recover a substantial portion of the proceeds of that lottery win. That was a case brought by the Center for Justice and Accountability, who've done very interesting work in this space, particularly in the US context. Private civil claims, they're difficult to bring. They have pretty stringent requirements. There's a few very basic requirements set out here. They're more set out in the framework, and if you go into a particular jurisdiction, it, obviously gets more complex. But one of the key issues is the fact that you need to be able to attribute harm and to a perpetrator that the victims have suffered. So it's not enough that the perpetrator has caused harm generally. You have to tie it to the specific victims. And also you need to find a court with jurisdiction to hear the claim. That's particularly, or can be very, very challenging because jurisdictional rules are quite tricky. And also you need a viable enforcement strategy. You need to be able to find or have assets that you can enforce against. Otherwise, it's just a piece of paper. A judgment's no good. Well, I mean, a judgment obviously has value, but if you're trying to achieve the purpose of getting assets to victims, you need to know what assets you're going after and how you're going to enforce against them. So I'll just quickly skip through this. I mean, there's a couple of benefits here to distinguish it from other models. Private civil claims, because they're brought by victims, you can compensate victims directly, whereas some of the other models, you can confiscate assets, but victims have no right to those. It's a discretionary measure, if at all, to apply those for the benefit of victims. They're relatively relaxed. Well, they're slightly more relaxed than criminal claims because it's a different evidentiary standard. And also victims retain control of proceedings. You don't have to rely on a public authority to initiate the claim. It's something that victims can do themselves. Challenges, we've spoken about establishing jurisdiction and about the challenges of enforcement. One of the really key issues is cost. These claims are very expensive to bring. If you're sort of talking about a big mass claimant action, the costs are very, very eye-wateringly large. So that's one of the key challenges here. And why that's important is if you're thinking about it on a kind of a cost benefits analysis, which if you're applying a kind of a slightly more commercial mind approach to it about sustainable funding, then, if you're putting in a lot of money and you're unlikely to get back much, it kind of calls into question the value of that commitment. So these cases may be, and that's a may, it's a maybe more significant or more appropriate for situations where there's a good asset footprint to go after, but not always. That's very much sort of a factor about who's funding it. But thinking through the cases, so if we think about our sort of high net worth, or sorry, head of state rather, potentially if they're located in a sanctuary jurisdiction, it will be very challenging to bring a civil claim against them. You might be able to bring a claim in the country where the victims are located, but if you're dealing with a post-conflict or a fragile state, it may be very hard to bring a claim of that sophistication in those courts. If they're not located in a developed country, which they're unlikely to be, or, it's hard to bring a claim using the established mechanisms and procedures in those courts. By contrast, if you're to look at, say, the facilitator who's internationally mobile, from time to time, they may be in a favorable jurisdiction. For example, they may have property in London or America or a European country. That may be enough to give a jurisdictional basis for a court to look into the claim. So even though the events took place in a different country, if the perpetrator happens to be resident, for example, in the UK, a claim could possibly be brought there. And similarly, if you have a member of the state security services who has fled to the diaspora and is in a global north sort of diaspora country, again, that may be a jurisdictional basis. So you can see how it depends. If the head of state subsequently comes for some reason to a developed country, it may be feasible. But if they're located in a sanctuary jurisdiction, not so much. Enforcement strategies. If you have to, basically, I think the gold standard for a claim of this type is you want to be going after assets that are located in the same jurisdiction as where you're getting your judgment. So if we look at the facilitator example and the former regime state security official, if they're located and they've sort of bought property, if they have a house or a couple of houses in the jurisdiction where you're bringing a claim, the enforcement process is relatively simple. You can also help conserve assets by getting asset preservation measures. That's brilliant. It basically simplifies the process a lot more. But if you're going after a claim or bringing a claim and your assets are located all around the world, it's a much more complicated process. And that's something you might see, particularly with a head of state, where they're using these complex structures to shield assets in offshore locations or just in multiple jurisdictions. So it's a balancing act. The resource limitation point we've touched on already, what's the potential, sort of outcome in terms of scale? Well, potentially much more significant with a former head of state, but it may be much more complicated and more expensive to get there. So it's not just a simple question of level of assets. You have to sort of think through these processes entirely. Moving on to another model, and this is I think an area that I think it's a tool used particularly in the anti-corruption context. So NCB confiscation mechanisms, it's an abbreviation, it's non-conviction based confiscation. And basically what it means is that you can, or civil powers, that law enforcement authorities have to seize the proceeds of crime without securing a criminal conviction. So it's to be distinguished from confiscation measures that take place after the end of a criminal trial. Obviously, it's a slightly easier process in some respects because you don't have to secure that criminal conviction in the first place. You're looking at just the assets. It's not, and it's done on a civil standard. So in the UK, it's a lower burden of proof. It also works by reference to the assets themselves. It's not about the perpetrator and it's not about the victim and where they're located. The jurisdictional question is much more tied to the assets, although we won't go into it, but there can be an international dimension to this, which, but essentially the point is, where is the property located? Can it be shown to be the proceeds of unlawful conduct? And then is there an NCB regime or mechanism that allows for confiscation and a public authority who's willing to take it on? If you can basically stitch together those, albeit very simplified factors, the mechanisms, then you have a decent prospect of seizing the assets. And just to give you an example, Malik Riaz Hussain, a Pakistani property developer, surrendered £190 million worth of property based in London as the proceeds of corruption. I should say, and just to be very clear, there is no suggestion of any human rights abuses associated with this. This is a pure corruption claim, but it shows the potential for this kind of mechanism. So these are obviously, slightly more straightforward. They're still complicated models, but they are potentially more straightforward or easier models to pursue. And because they operate on the location of assets, maybe they may be more flexible. So if we return to our kind of example of a head of state who might have, say, 5 homes around the world, it may be possible to seize those homes and to use those or to confiscate the value of those assets. What I should say here is that there has to be a link between the assets and the criminal conduct. So when you're looking at the sort of the archetypal model, human rights abuses don't tend to generate huge financial flows directly. They may do, but often it's part of a broader system. So actually you may not be tying the assets to specific human rights abuses, but perhaps to acts of corruption into which human rights can shape. So it's that idea of leveraging and using tools, and in fact using them, I guess, in their original context, but with a more of a human rights focus or a human rights gloss to sort of persuade decision makers and to basically to provide that basis for prioritizing that case or seizing those assets. They are also not silver bullets. Basically victims don't have standing in these proceedings. It's a law enforcement mechanism that's taken. The funds that are confiscated are basically subject to being subsumed within a state central fund. Although if it's a corruption context, the UN Convention Against Corruption means that there's an obligation to return funds to the state that they were corruptly obtained in. So it's not that second limb that we were talking about returning assets to victims is an area of weakness for this claim. That being said, there are some developments that may be positive in that example, in that instance. So in the UK, there are principles now governing the position of victims in corruption claims. And while it's about corruption, they provide that, I think, that precedent that we could build upon to look at putting human rights victims, or taking into account the position of human rights victims in specific human rights abuses cases, or even in the context of wider corruption, where corruption is linked to human rights abuses. I should also say that there are specific confiscation regimes for the proceeds of human rights abuses. The UK has one under the Proceeds of Crime Act, but it's quite narrowly construed. It's basically the direct proceeds of human rights abuses. As we've seen, one may not generate financial flows from doing it. You may do it to silence a political opponent, to silence a journalist. So it's not necessarily directly going to lead to a financial benefit. So that at the moment, they're not necessarily that helpful, but in any event, it provides a basis for development in the future. So the next and final example is just to look at sanctions, which are a very interesting area in terms of, I think, the lower end. And I should say we're working down at the moment through the sort of the effect. So, private civil claims are, I think, what you might call a gold standard for victims. You obtain money that goes directly to victims, and so doing deprive perpetrators of those assets. NCB mechanisms deprive perpetrators of assets, some scope potentially for assets to go to victims. Sanctions are about depriving use and enjoyment of assets by perpetrators, but they don't result in payments of reparations to victims. They're a qualified form of financial accountability. There's a number of regimes that they take place under. There's everything from the UN Security Council-based sanctions regimes, which are then implemented nationally, down to specific human rights regimes, so-called Magnitsky-type sanctions, of which the UK has just introduced a regime to mirror those in the US and Canada, and sanctions regimes are anticipated in the EU and Australia. The corollary of sanctions, of course, is that while they're less effective in scope, or they have lesser effect, they're much more straightforward to obtain. It's a discretionary measure by the executive, essentially a political measure. And I mean, to give you an example in numbers, we're sort of talking about the difficulty of bringing individual claims. The UK introduced its new sanctions regime with a listing of 50 individuals. So you can see the numeric difference. So it's a smaller effect, but potentially much wider application. And just as an example, General Monceau, deeply involved in atrocities against Rohingya, was subject to US Magnitsky sanctions, and is also sanctioned under the EU Burma sanctions regimes. So as we said, it's sanctions are flexible. They reduce or restrict the use and enjoyment of assets, and they're relatively straightforward to obtain. They're also, interestingly, I think, designed specifically as a behavioral change mechanism, which is a point we don't really focus on in the financial accountability context, but is an interesting attribute and facet. But they are a limited form of justice. There is no mechanism at the moment to apply sanctioned assets for the benefit of victims. That being said, Canada is looking at such a regime, and if that comes in, obviously sanctions may be very different, although I suspect that perpetrators won't want to put assets in Canada for that effect, so the actual practical impact may be limited. But also it's reliant on political will and wider strategic priorities, and we've seen that in terms of the nature of designations. The designations that are made don't tend to be people at the very top, they tend to be mid-level people. So if you take the Khashoggi case, there is, I think, MBS has not been sanctioned, but a lot of his underlings have, even though I think it's widely accepted that he's responsible for that behavior. So you can see how it doesn't really go to the people who are directly responsible. So again, thinking back to our practical kind of studies or our case studies, a head of state is a natural target, particularly if they cease to be politically important. So if they've been deposed, then that may be an easier time to get sanctions against them. Ditto for sort of former members of state security services. But it can be challenging. The lower you go down the sort of the pecking order, the less effect sanctions are likely to have, and so they're less likely, I think, to be a target. So unless there are assets located internationally or perpetrators are traveling internationally, it's less likely that the country will invest the political will in bringing a sanctions claim against them. So with that, hand back to Sandra to cover the final feedback session.
Thank you very much, Jonny. And we have about 5 minutes now to discuss and exchange feedback and to wrap up the discussion. And as you can see, I mean, my colleague Jonny has just had time to go through some of the models, but you can find a detailed description of the others with the same type of structure, outlining the challenges, but also the advantages in the framework, in the report that we have published. And you can see that different models have different control of the victims over the process. Some of them are controlled by the victims or can be triggered by the victims. Some other models are law enforcement driven. There is a difference of costs. There is a difference of the evidentiary standards, but also on the likelihood of victims seeing any money back as reparations. And which model do we use will depend on an analysis of all those factors, the jurisdiction, the evidence we have, etc. So with this, I would like to open the discussion with a few questions again for you guys to think about. One is whether we have included all the relevant models. And I think that you may be seeing a poll on your screen. This has exactly the same questions as we had when we started, but it's just for fun to see if the results have changed. And I can tell you what the results were in the first round in a second. But going back to some of the questions, so have we missed any models? Do you have any experience in working with any particular models, and can you share some of the challenges that you found? Do you think that the framework could be useful to your work as a tool, and what else could we develop thinking of the future? And just because it's a very has been applied recently in a number of contexts, I wanted to ask about sanctions, and what do you think about sanctions as a tool to achieve financial accountability? Is it too controversial? I mean, we see in two recent examples, it has been used against Belarus officials, but also against the ICC. So what are the risks? Is this a model that we should look at or not? Yeah, I would like to please open now the floor for people to intervene, ask questions, feedback. We are at the end of the session, so any reactions you have on the model would be very useful. Please raise your hands as before. Okay, Claire, please feel free to intervene.
Hi, me again. Yeah, I'm so interested in particularly the NCB confiscation. It seems like such a useful tool, and I was wondering if you're on the side like we are of working, we're really familiar with victims and the violations that they have experienced, but less familiar with the details of the perpetrators in terms of where their assets are and where they live and things. Would your suggestion be to kind of focus in on perpetrators that we know are most to blame, I guess, and then kind of try to find out where they might have assets? Or is the best thing to do just look for anybody that's kind of was involved in the commission of the crimes who we already know have assets in a relevant jurisdiction, and then work on trying to link their actions back to the human rights violations or the corruption, I guess, that occurred?
Sure, a really good question, Claire, and it's one thing we've been working with. So I think there's not a straightforward answer to this, but I think the traditional approach has been to look at perpetrator first, asset second. But the difficulty is there's a lot of risk associated with that approach. If they're sophisticated, sort of operators, it can be very challenging. So if you have known assets and someone who has a reasonable degree of connection, I think they're a real sort of priority target, because you just de-risked your case significantly, because you know what the assets are and you presumably have a decent basis for assuming there's interest or a basis for participation. But I guess it's just a case of working through in priority your targets based on the resources you have available to you.
Any other questions or quick reactions? We have about 1 minute and a half to hear any thoughts, any quick thoughts or reactions to the presentation. And Harry mentioned in the chat feature that he's interested in further exchange, and we are too. So this is our ask, that if this is an area of interest or you are working on this, we would really like to collaborate, put people in touch to the extent that we can, and see how we can take this forward. We are currently testing a few of these models. We don't have experience with all of them, but within the cases that we have at Redress, we are exploring how to take some of these models forward. I don't see any hands raised. So I guess that we can wrap up the discussion, and just to thank you all for participating, for listening, and please get in touch with us if you want to continue the conversation with us privately. And I've been asked by the organizers a little bit of a show act now, that as we close the event, I think they will try to get a snapshot of a few people participating. If we could please wave and put our cameras on for those that don't like to share their screens, that could be quite useful. Thank you very much, and thanks for participating. Thank you.